We can hear you now, though, so that's anything criminal.
Oh.
Well, that's the end of the session then. Is the volume okay though?
Just double checking it should be.
Yeah. If you just want to grab one of those bundles of documents on your way through. I better get you to start doing that now, so otherwise everyone online is just going to listen to me saying the same thing. I don't mind. You can introduce me. Why not?
You say that.
G'day. That's good. Yep. Good.
Yeah, we're good. I'll do this one so they can hear everything you're saying now.
Good.
There's not two more coming. Good morning.
We're ready to change, you know. Yeah.
So I'll wait for you.
Is there a way for people on Zoom to ask questions?
Yes, there's a chat box on there. Where's Simon gone?
That's all right. We'll work that out.
All right, Simon. Oh, Phil. All right, I'm going to start without him. He can wait. Thanks everyone for coming this morning. Welcome to CCF bright and early on a sunny Monday, which is good considering we had such horrible weather last week. Welcome to everyone on Zoom. You've got a chat box function, so if you've got any questions, feel free to ask in that during the session and Simon will ask them on your behalf. First of all, I'd like to start off by acknowledging the lands that we meet on today of the traditional owners of the Kaurna people and pay respects to their elders past, present and emerging. So today's topic is our annual topic of where we invite Tom in so we can hear and leave all excited about what award changes are coming. So I'll hand over to Tom. Tom's our preferred lawyer, legal advice for industrial relations. So I'm hoping all of you know Tom very well, in a good way, not in a bad way. I know I'm in a good way. So I'll hand over to Tom.
And unfortunately, that's the common refrain when I haven't spoken to a client for a while. I say things must be going well, but anyway, just as a plug, we are engaged by CCF to provide certain services, and part of that extends to a half-hour free advice for everyone who hasn't used our services before. So if you do have any specific questions, feel free to contact me afterwards. It's one of those things, 12 months is a long time. It feels like the last 12 months has been about 48 months or more, because so much has happened that if you actually stop and look back at yourself and what you were doing 12 months ago and think about where we are now, you'd think it was a lifetime ago. And that unfortunately seems to have also been the case with employment law. This time last year, We'd just started to settle down from the frantic digging that everyone was doing, trying to get their heads around COVID, trying to get their heads around stand downs and things like that, and then ultimately trying to get back to work and dealing with JobKeeper and the like. So it's been an absolutely phenomenal 12 months from a societal perspective, let alone from a legal perspective. Now, we're not here to talk about COVID. We're not here to talk about those type of restrictions. They kind of, hopefully, fingers crossed, are in the past. But what I did as I sort of went through and looked at all the dot points of things that have happened in the last 12 months, I realised that not only have we had that extraordinary change occurring in an unprecedented sort of way with the pandemic, but what we've also ended up having is a lot of IR issues had sort of been bubbling away, boiling away, and they just happened to all culminate at or about the same time. And so the key one here, of course, was the 2014 review of modern awards, which largely has concluded in 2021. And that's led to a lot of the changes we're talking about. We've got the superannuation changes, which from memory were legislated by Julia Gillard's government, which was in about 2012. That's starting to come to the fruition now, and so on. So we've just got this unholy cacophony of individual issues all coming together at the same time, and the result of that has been, or not only has been, but also will be quite significant, and especially for employers in the construction industry, which really is just one of those lucky awards that happens to have such a long and bitter industrial history that it seems to be about 5 times more complicated than most other awards, and that's unfortunate, but the way it is. So what we'll do today, it's a relatively unstructured session. It is an update. It's not intended to be on one specific issue. I will obviously be going through a number of issues, and I propose to spend most of my time after going through the update on what I would describe as the next thing everyone needs to worry about, and that's the casual conversion legislation that's come in, and there's a hard date of the 27th of September this year when most employers have to be ready, and so we'll spend a bit of time going through that. And hot off the presses, as part of your materials, is actually our update that hasn't even gone out to our clients yet. That's how hot off the presses this is. You are the first people to get your hands on this, but this is our update, just going through the mechanics of what needs to happen. So that will be towards the end of the session. But as I said, it's a relatively unstructured session, and it's intended to give you all an update. So please, if there's anything that I don't touch on that you want me to talk through, please put your hand up and ask a question. And for anyone on Zoom, Simon's sitting there waiting very patiently to take your questions and pass them on to me. So please put your hand up. There's no problem doing it, and you'll get a lot more out of the session as we go through. And indeed, one of the participants has already given me a couple of questions, and I'll get to them as we go through. So there's absolutely no problems anybody else asking questions. So what has happened? Well, most recently, the thing that kind of gets me up here every year is the annual wage review. That will take about 5 minutes to talk through, but that's obviously on the forefront. 1st of July is when it comes in. I'll deal with that in a bit more detail. The other thing that comes in on the 1st of July is the superannuation increase. So you get a double hit there. A few months ago, we had the new 2020 Modern Award commence, and that introduced a few changes. Some of those changes had been already decided and some of them already implemented, but that was kind of the end point of this Modern Award review, well, at least for now. And we had a few things that we went through, and we'll go through these in a bit more detail. The fares and travel changes we'll go through in more detail. Living away from home change we will, and same with allowances. I put a final dot point there, which was the shift work decision, and I decided not to put a slide in, but of course that's the first question that was asked by one of the participants. So I'll go to that now and just talk through what has changed with shift work. Nothing's changed. It's just that everybody's understanding has been proven to be wrong. And so the drafting of the clause is roughly the same. It's just the way it's been applied. So everyone always understood shift work to mean ordinary hours worked outside the span of ordinary hours. the common understanding of shift work in just about every single award. It is also the understanding of shift work in the general building and construction sector, but the civil construction sector has its own specific definition, which has been recently interpreted in a way that most people did not apply it. So the definition of shift work in the civil sector is any system of work in which operations are being continued by the employment of a group of employees upon work on which another group had been engaged previously. So what that means is that shift work is not night work. Shift work is defined by reference to the fact that someone came before you. And so if you've got night works and that's only night works, that's not shift work. It is work outside of ordinary hours. And so shift work requires there to have been a shift proceeding. It doesn't require 24/7, but it does require that this group follows on from another group. And so you can have a day and an afternoon, that's okay. You can have a day, an afternoon and a night. You could not have a day and a night if there was a gap between the two. But otherwise, it's work outside of ordinary hours. And the consequence of it being work outside of ordinary hours is that when you work it, it's paid as overtime. And so obviously that's a very significant difference between the 15% loading that's applicable to shift work and the 50% for the first 2 hours and 100% thereafter. So that's a major change in the way that people think, because myself included, have always had that understanding that as long as it's work at night, that's when shift work applies, and as long as that goes for more than 5 days, then it would be there'd be continuing shift work, and then if it didn't, then you'd be the 50% loading on all hours rather than 50% for the first 2 and double time after that. So that is a very substantial change and something that's important to consider. I have had a number of queries from members who are traffic controllers. That seems to be an area of interest at the moment. I don't know why necessarily, but it you know, traffic control is one of those things, especially when it's emergency type work, which is a huge amount of it. It's not a system where people are working one person to the next. It's a system where people come out on an ad hoc basis as required. And in those circumstances, it wouldn't be shift work. It would just be work outside of ordinary hours and therefore paid at overtime rates. The question arises as to whether or not that system of work in which operations are being continued by the employer, whether an employer who simply had a rotating set of operations, would that constitute shift work? And it seems the answer is no. It seems that it's the project. So, you know, for example, you're working on you know, one of the major infrastructure projects, that probably does constitute shift work. It doesn't seem to be a requirement that the particular employee is working back to back with another employee. It's that the operation, it has that system of work in place. So I can't see why you couldn't, for example, call a casual in for 4 hours ad hoc in that operation, but only in that operation and not more generally. So a bit of a debacle in terms of the way that the industry is structured, but unless and until there's an award change, that appears to be the interpretation of it. And then the final one, as I say, is the casual engagement legislation, which we'll become very acquainted with. And I'm glad that we don't have any rotten fruit or anything else in easy grip, because I suspect by the time I'm finished that, you'll want to hurl it at someone, and I'm the closest person. So what are we seeing in IR right now? What we're seeing in IR isn't IR anymore. It used to be IR. It used to be a system whereby industrial parties juked it out, and there'd be you know, a bit of give and a bit of take between the industrial parties, and you'd come up with a solution more often than not. And you know, when you didn't come up with a solution, you went to litigation. That's not what we're seeing anymore. It does exist. I'm not saying that type of thinking has completely disappeared, but what we've seen is a massive shift towards a compliance focus rather than towards an industrial focus. And by compliance focus, I mean the legislation is structured in a way that if you breach the legislation, there are pecuniary penalties that follow. Now, breaching the legislation means a whole lot of things in a whole bunch of different circumstances, but relevantly to employers, the National Employment Standards, modern awards, enterprise agreements, they're all either legislation or instruments created under legislation whereby breaches of those documents or of those requirements is a pecuniary penalty or a risk of a pecuniary penalty. Now, a pecuniary penalty can be up to $66,000 for a corporation. It's very unlikely to go anywhere near that number, but it could. But it's still likely to be a number that's got 5 digits and not 4. And the difficulty there is, of course, what's that number? Is it $10,000? Is it $30,000? Who knows? And so applicant lawyers have worked out that they can fund their legal fees by reference to finding some little technical breach and hammering the employer. So that's what we're seeing now, is the leverage being applied by reference to absolute niche issues. Like I've got, some of the, I won't say it out loud now that I'm on video, but some of the law firms around town are, every single pleading that goes in, they're just saying, and you didn't give me my Fair Work Info statement when I started my employment, or, even if you did give it to me, you didn't give it to me as soon as practicable, or, all these kind of things. Now, even where you got proof that the Fair Work Info statement was given, it just goes on to every pleading now, and the specific purpose of it is to leverage a better result out of you and substantially alters the risk profile, because you as the employer get faced with winning, and if you win the case, you still pay your legal fees. If you lose a case, you still pay your legal fees, and you pay whatever you've had to do, and you pay a penalty. And so it's essentially double or nothing on the employer as far as that goes. So what are the sort of red tape compliance? Well, the Fair Work Info statement is a classic one. We'll deal with the casual employment information statement shortly enough as well. Same sort of thing. The new casual regime itself is just an accident waiting to happen. And as we go through these, don't just think, oh, well, I missed a timeline or I missed a date. That is a potential pecuniary penalty application to be made against you. So if you've got a person who doesn't agree with your decision about casual conversion, their options are to dispute it in the Fair Work Commission or just to prosecute you. Not a great option from an employer's perspective, and a lot more capacity for disgruntled employees to apply pressure, which is what IR legislation or what IR litigation has always been about. So, what are the red tape compliance options in the award? I've just listed a few of these just for everyone's benefit. It's worth looking at this, and it's worth just considering, have you got your own systems and procedures in place? The building award actually requires people to be engaged in writing. That is not common across many awards. You can normally have a handshake. You used to be able to have a handshake. Now you're actually required to be engaged in writing. Now, it might be that the employment declaration, the tax file number declaration is sufficient to meet some of those requirements. It might be that you have some other combination of documents that meets them, but it is unlikely that you have something that meets the requirement in 12.3 for casual specific engagements. And if I just read out what you are required to do for casual employees. So clause 12.3 states, an employer, when engaging a person for casual employment, must inform the employee in writing that the employee is to be employed as a casual, stating by whom the employee is employed, the job to be performed, the classification level, and the actual or likely number of hours to be worked, and the relevant rate of pay. So not only do you have to engage them in writing, but you have some fairly specific ones, and trying to work out how a casual or what actual or likely number of hours the casual employee is going to work is near on impossible. Now, there are levels of compliance, but it's important that you have something in place, because if you don't meet those strict requirements in some form or another, you don't even have the argument to argue about whether or not you've sufficiently complied. You sort of fall over at the first hurdle. So those are the kind of things that are important. The other one, which is often overlooked, is the notification of the right to convert employment. And that's in clause 13, which requires that once an employee has got to 6 months regular and systematic employment, you, within 4 weeks, are required to notify the employee in writing of their right to convert under clause 13 of the award. Again, this is a clause that might become redundant with the new regime, but it's not redundant, and the IR regime doesn't work by choosing the most sensible of the two. The IR regime works by employers being required to comply with all of these tangled webs of laws until someone gets the courage to actually repeal the legislation that is creating this red tape, and that doesn't seem to be the current order of the day from any political party. So this red tape is likely to continue to tangle more and more and more until, I suppose, it becomes one unholy morass and someone takes that political courage to remove at least some of it. The other thing that I'd flag, it's not casual specific, but a lot of people don't work with an RDO system. It's relatively uncommon in the civil sector to work with RDOs as compared to, say, the building sector. But just to be very clear about that, the legislation, or the award starts from the presumption that you do take RDOs, and there is the capacity to agree to not take RDOs, but it needs to be recorded in writing. And that, from memory, and I don't quote me on this, from memory, that requirement for it to be recorded in writing is part of the new award. And so what we saw, not just in this particular award, but in pretty much all awards, there was a plain language redraft, and that plain language redraft slipped in a whole bunch of obligations that now need to be in writing. Now, you can have all the agreements you want. If it's not in writing, you've breached the legislation. Now, does it follow that the agreement is therefore invalid? Or is it just simply a breach for not having it in writing? And the short answer is we don't know. And this is the sort of grey areas that get created once these obligations, which have been around for a long time, start to get changed around. And look, I should also just put a really big disclaimer at the start, especially when we're talking about things like the casual legislation. It's entirely new law. And so I'm interpreting this based on my knowledge and understanding of the laws of interpretation, which I hope is at least reasonable. But you can always get weird decisions, you can get unusual decisions, and there's going to be a lot of litigation about what any of this means, which might upset the apple cart. But again, with all of these type of things, the important part of it is that you've got to at least do your best to comply, and then at least you're dealt into the game. If you haven't complied at all, then you don't have a seat at the table in terms of the dispute. Okay, so now we move on to the annual wage review. Nothing of any particular note other than a few bits to notice. Firstly, the decision was issued on, what was that, the 17th of the month, or the 15th? The 16th of the month. That is very late. You've got a sum total of 14 days plus whatever the remainder of the pay period that you're operating to get your systems updated. The rates themselves haven't been formally set because there is a formula that's required to be considered, and part of that includes consideration of expense-related allowances, which go up by a relevant CPI measure. They should be out soon enough. The draft determinations have been issued. So you know, it's a pretty unfortunate issue for employers to have such a small amount of time to deal with it. And especially unfortunate for the construction award, because we're coming up to about 10% increase over the last 7 months in terms of the way that these awards have increased. They increased by 1.75% in November. At the same time as that, there was the change to the industry allowance, which bumped up rates by around 3 or 4%. And now we've got another 2.5% on top and another 0.5% for super. So a fairly substantial change in terms of minimum award rates. Now, we've got an update of the bundle of documents, so I won't bore you in great detail. I'm assuming everyone's here because they work in the construction industry, but there are a bunch of industries, essentially the COVID facing, the tourism facing type industries, hospitality type industries, which had the most recent pay increase. That's been deferred till November. But otherwise, everyone other than retail for some reason is the 1st of September. but everyone else will kick off first full pay period on or after the 1st of July. Now, again, just a final bit, for anyone with an enterprise agreement, you don't need to pass on a pay increase unless the enterprise agreement provides that you have to, or alternatively, if your base rate of pay has been overtaken, if the base rate of pay in your enterprise agreement now falls below the award rate, you have to bump your base rate up to at least equal the award rate for an enterprise agreement covered person. That does not extend to allowances or penalty rates or anything else. It's just the base rate of pay. Okay, so that's the annual wage. Next one, this has been in effect or in legislation, as I say, since about 2012. It was meant to come into effect from memory in about 2015 and it was pushed out. And obviously the political winds were such that they couldn't push it out again. So, so we've got a 0.5% increase per year up until 2025 when it will become 12% super. And that is, at least at this stage, the end of those increases. I know that the Labor Party policy is to move it to 15%. So one never knows where that will move, but there's still plenty of time between now and 2025 for that to change. But again, we can only work with what we know. One thing that has got me scratching my head, and unfortunately I'm not in a position to give you an answer, I did try and find the answer yesterday, is whether that superannuation increase applies from the first full pay period or whether it actually applies from the 1st of July. And any of the literature I've seen does not qualify it with first full pay period. So I get the feeling that it increases mid-pay cycle, which if you've got software that is up to date will hopefully not be an absolute pain in the ass. But if it doesn't, if you don't have software or the software doesn't do this, which we use Xero, I have no idea whether Xero is going to do it or not. But that could also be a bit of a hassle, that pay period, to actually manually increase it, with the alternative being you could increase it at the start of the last full pay period in this financial year, and that way that you are covered, but obviously you've then spent the extra money in terms of that superannuation for that partial pay period. Okay, so we now move on to the fares and travel decision. This is one that's been causing massive headaches across the industry. It's going to continue to cause massive headaches across the industry, and I'm doing my best to interpret what is difficult to interpret legislation, an award provision. So one of the other updates that you've got in your bundle is our update on how fares and travel is now calculated. And the big change here is that it was previously a question of where's the employer, where's the site, one calculation per job, and that's it. So you were either in the 50K radial, or if you weren't in the 50K radial, there were only a couple of different cases. One was the employee coming from outside to site. One was the employee who already lived outside, and that was about it. There's probably a few more lesser cases, but that was the old way. That is no longer the old way. These arguments have been thrashed out in front of the Commission, and importantly, the idea that now we've got to do a calculation per employee was expressly raised in the Commission, and the Commission said, we don't care, that's the decision, this is what it is. So we're not here to cry over spilt milk in the sense of not getting an outcome that employers would obviously prefer, but here to talk through what it actually means. And so the simple case is for anybody who lives and works in the 50K radial area of Adelaide, basically nothing's changed. You just get your $17.43. Although I would flag, sorry, that was something I meant to flag earlier. For the first time in a long time, the daily fares and travel allowance will increase. The first draft from memory was $17.88 or something around about that ballpark. Don't quote me on the exact number. The reason that the travel allowance hadn't increased is because when they first set the modern award rate, they set it at $17.43, and they based any increase, because it's an expense related allowance, they based it on the CPI measure. It happened to be that when that allowance was made, that was when fuel prices were like $1.60 a litre. They then dropped substantially and transport costs generally dropped substantially. Cars got a lot cheaper, etc. And so it's taken roughly about 11 and a half years for that CPI measure now to go past the baseline index, which they used when the allowance was first brought in. So obviously that inflationary side of things has now caught up. So you would expect that allowance to continue to increase year on year on year from here on in. It might be the case that we do get some big dip in terms of cost of cars and anything else. But the reason the fares hadn't changed was not some peculiar, this is a fixed fare. It's just the formula happened to come out that it wasn't an increase and therefore it stayed the same. As I say, it will now continue to increase unless there's a big dip. So the basic case is obviously easy enough. That hasn't really changed. It's the second case. So it's the distant work provision that has changed, and it's changed drastically. So we're not talking about, a few dollars here and there. I assisted one CCF member who was down at Victor Harbour, and it was something like, instead of being $400 or $500 a week, it was $900 a week, roughly, in terms of transport costs once you move outside that radial area. So how do we work through what employees entitled to? The first step is if an employee was employed on on their first day of employment, and again, there's arguments here about whether it's first day of employment or first day of employment on a job, and if it's casual employees, is it new employment? There's a lot of complexity in that, but the broad statement is on the day the employee is first employed, if that site was more than 50k by road from their house, then all they get from there on in is the normal daily fares and travel. So that's the first exclusionary consideration, being, how far did you drive on your first day? I suppose the rationale would be something along the lines of, if you accepted a job and you're prepared to travel, well, that's a bit different to the alternative. Assuming the employee does not or hasn't travelled more than 50 k's on their first day, they're kind of in this middle zone. We've got the easiest zone being everyone living and working inside the 50k radial area. We've got this middle zone where you didn't travel more than 50k. You're not a sort of distance traveller by the normal sense of the word. And then you've got the people who did travel a long way the first day, and they're kind of back to square one in terms of just the base 1743. So it's this, the twilight zone in the middle, which is going to create the problems. So the premise is each employee's house has a radial area. If you live in the 50k radial area of Adelaide, that's your radial area. It doesn't matter whether you're right on the edge or right in the middle. But if you're outside that 50k radial area, your radial area then becomes the nearest PO, the nearest post office or GPO. I presume there's only post offices elsewhere in South Australia at any rate. But that's the point. So if you live out at say Murray Bridge, the Murray Bridge post office becomes the centre point of your radial area. Likewise, Victor Harbour or something, the Victor Harbour post office. So that's your area. Rule is, as long as you report for duty into your radial area, you get your 1743. All right. The difficulty is what happens when you work outside your radial area. So if you haven't done your 50k by road on your first day of work and you are required to report for duty outside your radial area, then the travelling time payments will likely kick in. There is one further exception, and that further exception is with the radial area previously, it didn't matter whether you lived next door to it or the complete other side of town. That was your radial area. Once you got to the edge of the radial area, then you got your payments. The new system, yes, you've still got the edge of the radial area, but the additional qualifier is that your journey must also be more than 50 k's by road. So if you live right on the edge of the radial area and you go across the radial area, you're not going to get anything extra. You've got to still travel more than 50 k's to get the benefit. Now, the example we used to use was the Novotel and Tanunda was the edge of the 50K Adelaide radial area. The driveway, the entrance gate was inside the radial area, and the building itself was outside the radial area. In the old days, if you did some work on the entrance gate, you got your 1743. If you travelled down to the to the main building, you got your 1743 plus you got your outside radial area allowance, and you got your travelling time payment as well. In that instance, you're outside the radial area under the new system. You're outside the radial area. If you've travelled more than 50 k's by road to get there, then you're entitled to the travel time payment. And it's a travel time payment that's the killer, because in the old days it was 1743, got you to the edge of the radial area, and then you paid the excess bit outside the radial area. Now it is door to door. So you get paid door to door travel time at ordinary rates. So it's not working time. You don't get paid penalty rates. It doesn't go into the calculation of your 8-hour day, but it is paid at ordinary rates, plus cents per kilometre if you're using your own vehicle. And otherwise you've got to pay the fares, but it's pretty rare, sorry.
So the radial area, is that just one standalone radial area from the GPO of Adelaide?
No. So if you live, like, so it's depending on where the employee lives, right? So if you live inside the Adelaide radial area, then that's your radial area. But if you live outside the radial area, a new radial area is created around the GPO or the PO box of your closest town.
So you said if you live inside the radial area, how is that general radial area calculated? From
Adelaide, so the Adelaide GPO, so draw a line, draw a radial area out around GPO, and as I say, like the Novotel at Tanunda, down south from memory, it's kind of just before Maiponga, like in that sort of zone. But so anyone inside that radial area is an Adelaide radial area person. But if you lived outside of it, your radial area is the closest PO box. And then it's reporting to a site within whatever that applicable radial area is.
Oh, is that still both ways, then door to door?
Correct. Door to door return.
Radius to site and then site to radius, but now it's completely door to site, back to door again.
Yeah, so in the old days, the 1743 got you to the edge of the radius, and then you paid the extra bit. Now you don't get the 1743, which is sort of lucky, because when it was first drafted, you did get the 1743 as well. But it's just door to door. So you throw the 1743 out the window, it is hourly rate from here to there and back, cents per kilometre if using own vehicle as well.
What about, so if you live at one end, that's another just inside it, and then you travel just to the other end, and it's more than 50 kilometres.
So that's okay, as long as you're inside the radial area, the rule hasn't really changed.
So it could be 100 k's.
Yep.
Inside, and it's still just.
Correct. But someone was on the phone and I was doing it as a bit of an exercise, just to sort of work out where it was, and it was like Salisbury to Noarlunga was like 49.5 k's, right? So in that instance, if someone was first employed, they live in Salisbury and they're first employed on a site in Noarlunga, obviously it depends which side of the suburb you're on. Like, you have to jump on Google Maps and do address to address to get the specific number.
Is it a straight line, or is it the?
So the radial area is a radius, but the 50 kilometres by road rule is distance travelled. So it's not as the crow flies, that second one. For the first one is as the crow flies, second one's not.
For the purpose of travelling, distant travel, the radius is taken from the individual's residential property.
Correct.
So, but for the purpose of normal travel, it's taken from the GPO of that one.
Sorry, so the purpose of any travel.
So I'm just trying to establish how many radiuses are there. There's the radius from the individual's home property.
No, there's only one radius.
There's only one radius.
Yeah, the slight exception to it, it's not an exception. The exception is the Adelaide radius is the radius for everyone who lives inside it. right?
So the GPO, LA GPO is for those that live within site.
Correct. Right, and then once you get outside of that, like if the person lives outside of that, then it's a different radial area, but it's always calculated by reference to where the employee lives. It's just in that capital city case, and it's not just Adelaide, like this is Sydney or anywhere else. In that capital city case, everyone inside that one ring is deemed to be in that ring. So, right.
That's the LA GPO. And so the purpose of distance travel, it's then taken from their principal place of residence.
Correct.
Where employees allocated a company car, or you
Yep.
permanently,
Mhm.
they qualify for any allowance?
No, that's not, and that's another part of the change. So, so one of the good parts of the change was that the old print, like the civil sector used to be quite common that you'd report for duty to the yard, you'd clock on at the yard, and you drive to site. Under the old award, technically you were still meant to be paid daily fares. Under the new provisions, you don't get paid daily fares if you clock on and clock off at the depot. But in terms of that payment, you don't get your fares if you're provided with a vehicle, but for the distant travel provision, you'd still get your hourly rate for travel time. And so it's still a fairly substantial saving because from memory, the cents per kilometre is about it's 47 cents when it's part of the your travel to and from. It's the travel between work sites about 70, but let's just say it's 47 cents per kilometre, and it's more than 50k journey each way. So it's at least $50 a day in cents per kilometre that you're saving without thinking about the travel time. Travel time is going to be more than that as well, so it's a lot of money we're talking about. But at least you're saving the $50 each day by giving them the vehicle.
So I work that's met all the rest of the criteria. And the only thing that difference is that they've got a company car. They will not get the kilometres, but they will still get the time
Correct.
for being more than that.
Yeah.
And like a 50k journey, if you're lucky and you're on a freeway, it's still going to be a 30-minute journey. So you're sort of looking at it, you're staring down the barrel of kind of at an absolute minimum, an extra hour's pay plus at an absolute minimum, an extra $47 there and thereabouts per day for the bare bones. But as I say, like for the Victor Harbour example, from memory, that was about 80 or 90 Ks. 180 kilometres times 47 cents is $85. You'd be lucky to get to Victor in an hour. So 2 hours each day. So 2 hours pay plus $80 in cents per kilometre. It's a lot of money.
Is Google Maps a good way to calculate the travel time?
Well,
Would that be a trustworthy source?
you can't, unfortunately, it's not something that's an agreed in advance type provision. It's what it took you. And if there happened to be a traffic jam that day, you then make the
trust your employees to be honest about how long that actually took them.
look. I can't say for sure how you do this, but Google Maps is a good starting point. And you do have to trust your employees. Like if they stop for a pack of smokes, do you get that travel time? No, you don't. So there is, but then proving whether you've stopped for that or what you stopped for. So as a rule of thumb, the Google Maps type journey would be appropriate. But it's actual travel time is what the provision says.
Well, when you're using that, it might give you 3 or 4 different options of getting to a place.
And that's why it's not scientific. It's just a yardstick.
So which one do you take? The employee's obviously going to say, I'll take the one that's
I've gone the long way.
The employer is going to say, well...
No, well, yeah, I mean, you can't, like, the employer, if the employer stopped for a pack of smokes and they claim that travel time, that would be a fraudulent claim because it's not travel time. So it's often in practice something you agree on an amount and everyone kind of lives with that, but that's not what the award says. And so there's that gap between trying to deal with awards in the real world and trying to comply with these provisions, which seem very simple and well-meaning, but when you start to apply it to real-world situations, becomes nightmarish. But like I say, the Google Maps, the shortest route is probably the starting point. And the employer, you could probably require the employer to justify why they spent longer than that. Yep, we'll pay you this much, and anything above that, you've got to explain why you're claiming that. And that way you place the onus on them. You're not preventing them from claiming, or at least placing the onus on the employee to justify additional travel time.
Can you put an agreement out with the employees with regards to what system you're going to use to determine it? So, for example, if you put a policy out and they agree to it that said we will use Google Maps and we'll use the shortest system, and if everyone agrees to that, would that therefore be legal in the event that
No.
you've taken?
No, well, yes and no. Like, is there a good idea having a policy to that effect? Yes, definitely, but not an agreement that black and white overrides the terms of the award, because it's a common law instrument. You can't override the terms of the award. So you can have anything above that included as part of a set-off arrangement in terms of an above award payment that you're already giving, or alternatively, the policy should be drafted that this is our yardstick. Anything above this, you're required to do X, Y, and Z in order to claim it. And that's okay, because the employee is required to justify their time, or can be required to justify their time. But if you don't have a policy in place to give some framework around it, the default position is it's the employer's problem. So yes.
I don't want to harp on this for much longer, but what about in the employment contract where you've got all your set-offs, you've got to put in place now? If that was stated in that and they agree to employment based on that you use in this particular methodology, would that then?
Yeah, so with a properly drafted set-off provision, it would not, like the way set-off works is not to change the entitlement, it's to change the way that you are satisfying the entitlement. So we're saying, I'm paying you $5 an hour above the award, that's $200 a week on your 40-hour week. If you've got an underpayment claim that's less than $200, well, it's absorbed into the above award payment. That's the gist of set off. So you're not changing the entitlement, you're just changing the way it's satisfied. Yes, that helps. So a lot of this, you're never going to comply with the award. That's the sad part of legal compliance, is that it's just impossible. Like the idea of having penalties came from work choices, interestingly enough. And the idea was it was a fundamental change to the way that we did IR law. And it was a minimum set of simple conditions that were backed up by big penalties. But that was because they were a minimum set. What we've ended up with is the worst of both worlds. We've ended up with absolutely complicated, impossible to apply in practice provisions and penalties, the same penalties to ensure compliance. So having a set-off clause, having all those arrangements in place is absolutely critical. Having a policy, I'll get there in a second, having a policy in place which structures how you're going to do this and places the onus on the employee to justify above whatever that amount is. All of that very important. Is that a 100% perfect answer? No, it's just way better than the alternative.
I'm still confused about their residents. We have a long-term employee who has elected to remain casual over a period of years, and he has moved from West Lakes to Goolwa.
Yep. So. Yep. So you've hit the nail right on the head as one of the bits that we don't have an answer to. Right? What happens if the employee moves? And the short answer is, it appears that it's just too bad for you as the employer if they move. And then the question is, and this is the bit that I haven't really got my head around, the question is, if I then don't give work to this person because I'm not paying $1,000 a week for someone to come from Goolwa to Adelaide to do their job, would I be taking unlawful adverse action against them by doing so? Because at least the existence of that allowance is proximate to which is a workplace right, is proximate to the exercise of proximate to your decision not to give them hours, and it's a mess. There's no answer, sadly. I'm of the view that if the cost was prohibitive, that you would be able to say, look, it's too expensive. I can't give you this work. And then the unfortunate bit is the employee is kind of stuck because they can't choose to waive their rights under an award. It might be that you could enter into an individual flexibility agreement with them. It might be. It might be that you could agree on a break in employment and then and it was a legitimate break and so on. But all of that is not clear. And because it's not clear, it involves a level of risk. And you can do things like having policies, etc. You can do things to reduce that risk. You can do things to put yourself in the best position to argue with it if it ever comes up. But that is one of the gaps in this that no one's got an answer to yet.
Is it then kind of just cheaper to get them to start at the depot?
Yeah, but then their travel time. So then you do pay penalty rates on their travel time. So it becomes a question like, and because of the way that this has so massively increased now, it actually becomes a really important question. Like if you're tendering for work and you haven't budgeted $500 extra per man per week, I should say, to do the job, that is huge. Like that's not a small estimating error. That is a massive change. Is it cheaper to go to the depot? Well, $17.43 or $17.88, $18, let's just say, for just about any job you can think of, if they clock on at your yard and then drive to site and back, you'd be struggling to get that done in less than half an hour, even for a close job. And half an hour's pay is round numbers pretty close to $18. So paying daily fares is probably more efficient than, especially inside the radial area. $17.43 for the person to drive themselves there, so no transport costs. They provide their own vehicle and no travel time. It's a relatively small expense. Is it better or worse? You'd have to do your numbers, but my gut feel would be that it's probably better to get them to start on site. And it's just now that you've got to work out between a relatively small and known quantity and a massive quantity that depends on where the person decides to sleep each night, which it's problematic, and it's that moving during employment that makes it way more confusing.
Just one more. Those that travel outside the radial area, distant travel, the time travel, is that ordinary hours or?
No, it's just pay. So it's travel time. So travel time is a separate time. It's not part of your working time, but it's just paid at your ordinary rate.
Okay. So a scenario, we're at Edwardstown based, we got a job at High Marsh Island, we hire a minibus, we put 12 guys in it and take it there. So they get paid their $17.88 to come to the depot, I would assume these days.
Are you paying them for the travel time from depot to Hindmarsh?
Yeah, so we've now whacked everybody on a minibus to take them to High Marsh Island. So they obviously get time paid for time travel both ways. Is that in time and a half or?
So yeah, that might act worse again. If they report for duty at the depot, that's when they clock in. All right. And then they clock off on the way back. So in that instance, it's working time and therefore time and a half and double time would apply, which would most likely be the most expensive of the options. And especially in a minibus, it's going to take longer as well just to travel. So, the unfortunate reality is in that instance, it's still cheaper to make them drive or at least provide a vehicle. And that's, the cents per kilometre becomes a relevant consideration, but there's just no neat, clean answer to this. Victor Harbour, I just know because I did it for someone else that that sort of area, it was about $800 or $900 a week versus $400 or $500 a week under the old system. Like it was a significant difference. All right, so there's an update that you can read through. Note that the numbers will be redundant, like the actual dollar value will be redundant soon enough because of the new increase, but the principles remain the same. Just another one, which is actually somewhat nasty and sort of gone under the radar, is living away from home allowance. That's also changed quite drastically. In particular, the Commission decided that it was a major problem, employees being hired at the gate, the idea that you could say to someone, I'm employing you, but I'm employing you as a local. And so there's this quite rigid process that an employer and an employee need to go through to determine what the employee's address is for the purpose of living away from home entitlements. You know, almost to the point where you've got to get a sworn, a certified copy of their driver's license or something similar, just so that they don't take a job that might otherwise entitle them to living away from home, which is, quite counterproductive. The number of people have called me and said, I've got a guy who's begging for a job. He's happy to stay with his auntie. Is that okay? It used to be, but not anymore. Now you've actually got to go through this process, including, as it says, must take reasonable steps to verify the identity, including obtaining documentary proof. So you can't just take their word for it. You've actually got to go and get something that shows what this person's address is to determine the living away from home entitlement. And then the second bit that's been added in is a significantly revamped rest and recreation provision. Doesn't matter so much for short-term stuff because it only applies once you've gone more than 8 weeks, but specific provisions about what you get, and that is for each 4 week service, you get 7 days unpaid rest and recreation leave, which is 5 days exclusive of travel. So, a full week, as long as it's only a day each way travel. If you're traveling out to, remote WA or something, it's a 2-day there and back journey to be, 9 days required because it's got to be at least 5 days exclusive of travel. And then after 12 weeks, you get 2 days paid rest and recreation leave. So that's something that gets taken during that unpaid time. But the point being, if you've got more than 12 weeks on a job with living away from home, then the person now has this new entitlement to rest and recreation leave of 2 days per 12 weeks on the job. Everyone. This is anyone who's living away from home. Sorry. No, good question. I'm pretty sure it's anyone. But let me take that on notice because my internet's just dropped out. I'll keep going. I'll come back to that before we finish. Another change is the provision of boots, tools, etc. It used to be that only tradespeople got tools, and it used to also be that safety boots were only applicable or required to be paid under the award. I think it was for refractory bricklayers, but it's now expressed in the award that you have an obligation to provide or reimburse for the provision. And I should say that the starting point of the obligation is actually to reimburse. And so you lose a bit of control in terms of what type of boots. You can buy pretty nice boots and you can buy pretty crappy boots. So just be mindful of those new provisions. It's arguable under the terms of the workplace health and safety legislation that you have that obligation now anyway. So I'm not going to go into great depth there, but the point being that to the extent it used to be arguable, now the award's very clear about what that obligation is.
Is that a request or do we have to advise?
So let me get it exactly. So the clause says where employers are required either by the employer or by legislation to wear steel-toed capped safety boots, the employer will reimburse employees for the cost of purchasing such boots on commencement of work. Subject to fair wear and tear, they'll be replaced each 6 months. So it just says you will reimburse it on commencement. It doesn't say on request, but by definition, a reimbursement is on request.
That's right.
Yeah.
They must produce a receipt or something like that, correct?
Correct. Correct. So look, I mean, most people provide equipment, or at least make it clear that you are offering to provide it at this rate, and then you've set up a position where you can say, well, I provided it, or gave them the alternative that if they wanted to go out and buy the Ducks Guts version, well, we reimburse up to the value of this reasonable boot.
Can we do a PP allowance for them instead?
Not really. The problem is it's a reimbursement, so an allowance would get you most of the way. As long as it was generous enough, it would be enough, but it's not quite the same. It's close. You could probably structure an allowance to comply, but not as a general, yes, you can do it. Yeah, specific advice required is a short answer.
The based on commencement of employment, surely if they're coming from another employer and they've got boots, you don't need to. They're not going to ask, but they have the right to ask for boots.
Sorry for everyone on Zoom, you can't see me. I was just nodding. The short answer is yes. They have the right to do it. Is there a capacity to double dip? Probably. Produce the same receipt to 3 different employers. I mean, you can see these kind of well-meaning provisions getting abused, but
And then each 6 months as well. We're not to chase them.
no, not to chase them.
That they have the right at 6 months if they're doing, if they no reward as well, they have the right to.
Correct, and it's subject to fair wear and tear. Like if you sent them to a site that just trashed their boots within 3 months, then 3 months would be the number. Okay. Just before, I think this is the last slide. Yep. The next we move on to the casual conversion, but there was one more question that was asked from the floor earlier to do with traffic. First question was, TCs are classified as CW2. Traffic controllers are CW2. I'm not entirely convinced that all people involved in traffic management work are traffic controllers, but the risk-averse approach is to say that they are all CW2, at least if they're ticketed. I think that would be the yardstick. If they're not ticketed, I think you can probably call them a CW1, but I'm not aware of any case law on this to see whether that's the case. So again, specific advice would be recommended on that one. And the question is the leading hand allowance applicable if someone is appointed to supervise a fellow traffic controller with the same qualifications? Short answer is yes. So the definition of a leading hand, it's not even quite an allowance under this award. It's arguably part of the base rate because it comes under clause 19. And it says a person specifically appointed to be a leading hand must be paid at the rate blah, blah, blah. And then the term leading hand is a defined term. And in the definition section, it says leading hand means an employee who is required to supervise or direct or be in charge of another employee or other employees. So you might have 2 carpenters, you might have 2 traffic controllers, you might have 2 people with the same qualifications. If one person's appointed to direct, supervise or be in charge of the other person, then that would be a leading hand position. No, that would be where the leading hand allowance would be applicable. All right, look, it's 11:06. Do we have a break or are we just going to go through? I'm totally open. Unless anyone has any more questions about awards or any of those sort of entitlements, we'll move on to the casual stuff next. Sure, let's have a break. So we'll have a 10-minute break. We'll go back to the good casual conversion stuff. You might as well come in recharge for that. So if we come back at 15:15, so just an 8-minute break, if that's all right. There you go.
Quite good to see you.
Yeah.
In the lights.
Do you wanna-
Yep. Testing, yep. Okay, thanks everyone. A little bit longer than we'd hoped, but I had quite a few questions. There's a lot of confusion about shift work, and it might be that we put a separate session on just to deal with shift work, because it was a nasty decision that upended decades of common understanding in terms of how those provisions applied. So it's unfortunate, but that definition is quite it's quite unique and quite clear in terms of what's required, which is that you need to have a group, some sort of a system of work where one group follows the other group in order for it to be shift work. Otherwise, it's not. And that's the unfortunate reality of that definition. Speaking of unfortunate realities, we next move into this question of casual conversion. This is something that when it first got passed about 3 months ago, I read the legislation and was so thoroughly confused by it that I kind of gave up and just ignored it, hoping it would go away, but it didn't. And in fact, there is a time not coming up in the near future, but soon enough. So we're about through the transition period. You've got about 3 months before the legislation comes into effect in its full form. And so what we want to do now is just start talking members through what the requirements are and what the pitfalls are, because going back to what I said in one of the first slides, it's all about compliance now. And this, unfortunately, is a huge amount of red tape in terms of compliance. So if we all turn our minds back to WorkPack litigation, there was a case where, or a couple of cases where the full federal court has found that an employee who was called casual but worked a rigid roster was in fact not casual. And the way the legislation's drafted, when it talks about annual leave entitlements, etc., it doesn't say this applies to a full-time employee. It says this applies to every employee other than a casual. And so the court said, well, this person isn't a casual, therefore it applies because there's something other than a casual. It's not a casual. And so the idea was that there was going to be this big double dip, and there is at least some potentially significant risk. We haven't seen it translate into significant litigation, but there are a lot of people waiting in the wings, and there are a lot of class actions that were being put together. So there was an impetus for the government to pass this legislation, but in the sort of classic political sense of the word, the government found it tough going. And indeed, this legislation was part of a major omnibus bill, which included a whole series of things, particularly to do with enterprise agreements that would have made life a lot easier for employers. All of that got jettisoned, and basically the only piece of that legislation that got passed was the casual conversion piece of work. Now, there is apparently other bits of legislation that are being proposed to be put forward from that bill, but at this stage, this is the only one that's gotten through, and it really depends on what the crossbench support is as to whether any of it will get through. So the legislation does a few things. The first thing is that it creates a statutory definition of a casual employee. The second thing is that it requires the provision of this casual employment information statement. And then the third thing it does is create a regime about conversion from casual to permanent employment or offers of that, which includes a positive obligation on some employers and a residual obligation on everyone else. And we'll talk through them in more detail. So I'm just giving a broad overview of what it does. So what's the definition of a casual? A casual is not simply a person that you call a casual. The legislation creates a definition which says a casual employee is determined, or whether a person is a casual or not is determined at the time that you engage them. So it's not something like WorkPack, which might or might not have been casual and over time might or might not have morphed into something different. It is only at the time the person is engaged. And the assessment is whether or not whether or not the person was offered employment on the basis that the employer makes no firm advance commitment to continuing and indefinite work according to an agreed pattern of work for that person. So you can call them casual, but if you gave them a firm commitment of an agreed pattern of work, et cetera, that would not be casual under this definition. When you drill a little bit deeper into it, and without boring you with the nuts and the bolts of this, the key is the advance commitment. And so it's important that your casual contracts are drafted in a way that makes it clear that there is no advance commitment, that hours that are offered might be rejected, or that an employee can reject hours offered, and alternatively you can withdraw hours that they might otherwise have worked, et cetera, et cetera. So they're relatively standard form clauses that need to go into a contract, but it's crucial that does go into a contract so that you've got it. Now, how does that gel with the provision I was talking about earlier, where you have to actually say the actual likely number of hours of work that's going to be offered to a casual employee in order to comply with the Building Construction Award? Short answer is too bad. You as the employer have the obligation to comply with both. And so there is a little bit of wording that you can do. It's not hard, but it's something that you need to look at within your own systems. How do you engage your casual employees? What are the terms of that contract? And in particular, do we have those right clauses in terms of no firm advance commitment? Do we describe them as casual? Do we still tick the box in terms of compliance with the award provision? And although it's not on these slides, do we also clearly articulate the casual loading? And that's a really important element of the legislation, which I don't have a separate slide on, but you get paid a casual loading. The casual loading is worth more than the leave entitlements that you forgo as a casual employee. The practical reality is very few people actually accept an offer of permanent employment, except if you don't remove the casual loading. And you don't have to offer the casual loading. That's the whole point of the casual loading, is you would lose that. But the result of that is casual conversion in one form or another has been around for a long time. And it's very rare that we actually come across a situation where an employee accepts an offer of permanent employment. They much rather have the money in their pocket. So is that a question? Or? No? Okay. That's what you need to do. I'm not going to go through it in great detail other than to say definitely look at your contracts for engaging casual employees. The second thing is the casual employment information statement. In a staggering piece of red tape, the government decided to issue a separate casual employment information statement rather than combining both the Fair Work Info statement and the casual employment information statement together for the sake of having one less document. And so all employees need to get the Fair Work Info statement, and the Fair Work Info statement talks about various rights and obligations, and then there's the casual employment information statement separately. So your casuals need to get two information statements. And I mentioned previously that some of the applicant firms around town are, putting a line item, for every prosecution. Oh, and I didn't get this. Well, now there'll be two line items, and now they'll be thinking $132,000 rather than $66,000. So again, a relatively simple step, but something that a lot of people overlook, and something that can then expose you as a result. Now, again, a lot of this should be process driven. As part of your employment documentation, as part of your induction documentation, you should have clear evidence that, that the employee ticks off. I've seen my policies, I've seen my Fair Work Info statement, I've seen my casual info statement, and they sign off it. So you've got some evidence to show actual delivery. But again, a simple concept that has potentially substantial ramifications. So be mindful of that.
With the Fair Work Information Statement, would it be best practice to reissue every time there's a change in it to all employees? Would that be a safeguard approach?
Not really. The problem with employment is once you've breached it, you've breached it. And it was sort of like the old conventional wisdom was, you should voluntarily report yourself to the Fair Work Ombudsman. I mean, you couldn't do anything stupider. Because unfortunately they don't have that mercy. It's sort of like going to the cops with a big bag of drugs and saying, look. And that's really unfortunate public policy, but that's what it is. You know, it should be a question of voluntary compliance. It should be a question of rectification. It should be a question of degree, but it's not. And so sadly, the best thing you can do is to make sure that everyone gets one up front and have evidence of it. If not, you might as well provide it later on. There's no harm in doing it, but it doesn't give you any extra protection other than from a practical perspective. You know, and look, if there is a penalty proceeding and you get it all the way to a decision on penalties, you will likely get a reduced penalty if it shows some sort of levels of good faith. But the reality is this is just leverage. It's not really about the compliance. It's just about how much money the disgruntled employee can get. Okay, so they're the two relatively straightforward concepts. The next one we move into is the positive obligation to offer permanent employment. And this is the one that is likely to trip people up the most. So the starting is it applies to businesses that are not small businesses. A small business is defined in the legislation as a business with less than 15 employees. And the count of employees is a head count of all full-time and part-time people. So each part-time person counts as one. It is not a full-time equivalent calculation. And in addition to that, any casual employee who is engaged, I think the part of this legislation was to actually change the language, but broadly speaking, on a regular and systematic basis. So if you are a small business, this does not apply to you, but 15 employees isn't exactly a large business.
Do paid directors, wage earning directors or salary earning directors, are they included in that account?
It's a complicated question with directors. The fact that you said they're a wage or salary earning director means they almost certainly are. You do need to be a little bit careful, but you also need to be also a little bit risk averse on this because, you know, you can litigate and lawyers do, they get caught up in all these kind of questions. Typically, because this doesn't, like this small business doesn't just count for this, it counts for redundancy, unfair dismissal laws are different, etc. So we do advise a lot of people on this, and almost invariably you'd be risk averse and you'd count the director, you know, with one eye on the fact that maybe you don't need to do it, but you know, you're not usually trying to be so scalpel-like that you kind of work right on the margin. You've just got to have that buffer zone just in case. But yeah, you know, my legal practice, I'm a director, but I also draw a salary. Very clearly, I am an employee of that practice. Okay, so that's, sorry, the last bit about that. Associated entities are also included. Now, what is an associated entity? It's a broader test than the fact that your related body's corporate. It broadly applies in circumstances where either one entity controls the other or there's another entity, and by entity they also mean person, that controls both of them. And it's a bit deeper than that, especially when trusts are involved. It's quite complex. But again, the risk-averse approach where there is that kind of a relationship is to include them because you know, you can be either right and it's okay, or you're wrong and you get prosecuted. So it's an unfortunate side effect of the way that IR law is implemented that occurs. So how does the casual conversion process operate? There is a transitional provision which we'll deal with for any existing casual employees. So this that we're talking about only applies to a casual employee employed on or after the 27th of March this year. Right, so this process is the process that we'll deal with going forward, but we're going to talk about what we do with existing employees separately. So the first thing you've got to do is you've got to actually have some kind of an alert or system in place to work out when the employee clocks up their first 12 months of service, because that's the relevant date. Now, on that date, you make an assessment about whether or not you have to offer them permanent employment. And that assessment is by reference to the fact that the employee during at least the last 6 months, right? So it kind of doesn't matter what happened in the first few months of employment, whether they were, you know, sporadic casuals or whether they were a bit more consistent in terms of their working patterns. What matters is that at least in the 6 months leading up to that 12-month anniversary, they were working a regular pattern of hours. And what is a pattern of hours? No idea. That's one of those things that we're going to have plenty of litigation about what constitutes regular. And then the second part of that is without significant adjustment, the employee could continue to work as a full-time/part-time employee, as the case may be. So if you're sort of doing regular 20 hours, that's the part-time offer. And if you're doing regular 38 plus hours, that's where you put the full-time offer. That's what you'd be looking at making the offer. Now, as I said, this idea of what's regular, you know, regular and systematic employment was the language that was previously used in terms of casuals. And there is a truckload of litigation about what's regular and systematic, and that has changed over time. You know, there was some decisions suggested that you didn't need to have any particular pattern of work to be regular and systematic, as long as you knew that you were going to get a number of hours each week. The legislation does say it's got to be a pattern of work. So I suspect that it's a tighter definition than the way regular and systematic had been eroded over time through judicial interpretation. But there is definitely no hard and fast black or white answer. And if anyone is looking for that, unfortunately, we're not going to be able to give it to you. We're just going to be able to help you through to minimise your risks and to look at what the processes are. So the second part of it is without significant adjustment, the employee could continue to work as a full and part-time employee. This is directed at the nature of full and part-time employment. My view is that you would look back to the provisions of the applicable award or enterprise agreement to get some sort of guidance about what that means. So for example, if you have like traffic control seems to be the order of the day. So let's use that as an example. If you've got a person who is working, you know, every week, maybe 20 hours a week, but those 20 hours, you know, sometimes they're on a Monday, sometimes they're on a Wednesday, sometimes it's 8 hours, sometimes it's 4 hours. That doesn't gel at all well with part-time employment, because part-time employment, you've got to agree on set hours of work, and anything outside of those agreed hours is overtime. Right. So my initial reaction is, at least in the context of someone working less than 38 hours a week, that would have to be a fairly fixed pattern of work in order to meet that definition of part-time, because I can't imagine why, famous last words, can't imagine why yourself in a position where you'd have to pay overtime to someone to keep them working. That's what they mean by this without significant adjustment. So it might be that, you know, there's half an hour starting time, finishing time difference or whatever. And you might say, right, without significant adjustment, you know, I'm just going to set you at 9 a.m. every day or whatever that is. So that sort of thing would be captured. The construction industry is obviously a very different industry for a lot of reasons. And one of them is site conditions change all the time. You know, you might have to start late one day because you're waiting for a crane for some other trade to move, or you might you might have to work different hours to suit client requirements on a particular job, but not on other jobs. So there's just so many variables with starting hours that I can't see many circumstances where the part-time side would ever actually play out in practice. And the reality is there's very little part-time employment in the construction industry as a result of that. Full-time is a far more different proposition, because you do have a lot more flexibility rostering full-time employees in terms of starting times, etc. You can do that. You're able to do it. Okay, that's so the first part is that you've got to decide whether that person fits that, and then you've got to decide whether you're not required to make an offer. And the reason you're not required to make an offer is because you have reasonable grounds not to. That's about as far as the legislation goes. That's it. What are reasonable grounds? Well, everyone's sitting here saying lawyers feast, and I'm not disagreeing with you. The reality is no one's really going to know what is meant by reasonable grounds until there's plenty of litigation in this space. That's just the reality. It's not just reasonable grounds. The legislation is quite clear it has to be based on information that is known or reasonably foreseeable at the time of making the decision. So whereas in other instances, reasonable grounds is an objective test that's determined by the judge at the end of litigation, this criteria is further reduced because it's only what you knew at the time of making the decision that's relevant. So
if you've got a casual end of a job, we get jobs, we get a casual and go, okay, you're all going to go and work on this job here, and it's going to last for 4 months. After that, we don't know. But you might have another job, because it depends on how many jobs you get. You know, you have a baseline organisation structure of people who have all your jobs, and you're going to fluctuate because that's where you have labour hire and you have casuals. If you come along and got a casual and said, look, I'm going to put you on this job for the next 4 months that we've got, it could be an average of 35 hours a week to 50 hours a week, depends on, you know, the fluctuations in there. Can that happen? You do that, and then after that job, okay, if we've picked up another tender, we've got another job. You know.
So what you've done is you've picked up the fertile grounds for disputation. Can you do it? Sure. And we'll talk about the process in a second, but keep that in the back of your mind, because in some ways it's a process that you've got to go through. And in some ways, this is more about making sure you go through the process because, as I say, the overwhelming majority of people aren't going to accept your offer, at least as far as my historical experience of these offers goes. And we've been through plenty of times where whole workforces have been offered it and like maybe one person sticks their hand up, maybe. And as I say, because you get, like the casual loading is paid on overtime. Annual leave is not paid on overtime. Sick leave is not paid on overtime. So if you're working any amount of overtime, you're way better off financially getting a casual loading than you are getting leave entitlements. Some people prefer the leave entitlement. Some people prefer that comfort. Okay, cool. And that's fine. But my experience is very few people do. It might be that now that this is a nationally advertised concept that people start rushing to get leave entitlements, but you know, notwithstanding that our legislation and awards are made on the basis that employees are idiots who aren't able to look after themselves, the reality is most employers know exactly what they're getting in their pocket each week. No matter how unsophisticated they are, they still know what they're getting in their pocket each week. And you know, they make a decision based on what they're going to get, and it's usually a rational decision, and that has typically fallen away. So the key here, in my view, is the process and making sure you've got your ducks lined up, because the way the process plays out leads to a decision which could be challenged, and that's where we get to. So if you're going to make the offer, you've got to make the offer in a 1 day window. So this is the key bit of compliance, is that you've got from the 12th month, the completion of the 12th month of service, you've got a 21-day window to do this, and it's either to accept it or to reject it. Now, there is a third option in here, which was actually that little thing down the bottom. What about employers who don't meet the above definition? Really unclear here. The legislation does not expressly deal with it, and so I'm working on the basis of just interpreting how the rest of the moving parts work. But it appears if the casual doesn't meet that definition, the obligation falls once, and that is on the 12th month anniversary. If the person doesn't meet that definition at that time, then you don't have to make an offer. You don't have to do anything. One of the things that bothers me about this is the nature of casual employment is, by law, an offer and an acceptance each time the person works. Each shift is meant to be a separate engagement. And so I just wonder whether someone's going to interpret this in an impossible way, which would be that you have to somehow or another work out when it is that the person became a regular casual, and then the clock ticks there in the 12th month anniversary of that. So it is a mess if that goes down that path. But unfortunately, that is a potential interpretation, and that's something that we might see play out depending on which judge gets it. Because unfortunately, just like the WorkPac litigation, you know, we've seen that courts don't necessarily make a decision based on the sensible outcome. They make a decision based on the legal outcome. And so I can see that door being open.
And we need to get this the applicable date, 27th of September, right?
Yeah.
So even though they may have qualified beforehand,
Can we deal with the transitional in a second? Sorry, we will get to that because this is just what applies to anyone who is employed after 27th of March, right? So there's going to be a bump on the 27th of September, and then nothing for another 6 months, and then the process will be playing out from there on in. Okay, so
You have to offer that once, don't we? So after the 12-month period?
Correct.
Not every 12 months.
not every 12 months. Subject to that interpretive issue, but as far as I can read the legislation, it's intended one consideration. So basically, the minimum you need to have is some sort of an alert that tells you when someone's clocked up their 12 months, and then you've got to decide, have they met that definition about the pattern? If no pattern, then cool, move on. Now, arguably, you would still send a letter to the person just to cover your base. The risk-averse approach would be, if you decide the person is not eligible because they don't work a regular pattern or not, I would still probably send them that letter and say, look, you don't meet the criteria, just letting you know that if you ever do meet the criteria, you can exercise your residual right. And we'll talk about the residual right, which is the second part of this. So if you're going to reject the offer, sorry, take a step back. We haven't got quite through the whole acceptance process. So the employee then has 21 days to consider your offer. So the timelines are 12-month anniversary, you've got a 3-week window. The employee has a 3-week window from whenever you respond. So if you responded 12 months and 1 day, it would be 21 days from that day. If you responded right at the edge of that 12-month period, then it would be 21 days from that day. And so you've got to put a written offer to them, and it's got to include details of the employment. The legislation only really deals with the hours of work, etc. But I think in reality, you'd be sending them a contract, which would clearly set out what the terms that you were offering them would be so that they could accept it, and then you've got an accepted contract. So they've got 21 days to consider that offer. If they don't do it in a window, then it's deemed rejected. So it is a firm time. It's actually 22 days, just to be clear, when we're talking about days on this legislation. The first day doesn't count. You would always assume it did in terms of your own actions, just in case, but in terms of the employee's actions, it would be 3 weeks plus 1 day before the actual offer expired. But if an employee accepted the offer on the 23rd day, you'd be a brave employer to turn around and say, too bad, so sad. You'd just, you're asking for trouble, and you're asking for a bad interpretation of legislation if you act that way and turn up to court relying on your rapier-like wit in terms of application of this legislation. Now, if the employee accepts it, that's not quite the end of the process. If the employee accepts it, then the employer must discuss it with the employee before sending a notice. So you've got to sit down with the employer and go, right, cool, you've accepted it. Don't know what you've got to discuss other than really when it commences, right? So, you've got to discuss about when that might commence. The default position is it will be the first full pay period on or after you sending this final acceptance notice. So you've got to talk with the employee. Presumably, it's only if you're trying to go outside the norm, you've got to do much more than just discuss it with them and say, yep, no worries, thanks for accepting it. Unless you have any really strong feelings about it, I'm going to, this will commence on and from this date. And away you go. But it is a default position. So you can't go to the employee and say to them, this is going to commence in 3 pay periods time. It is going to commence on the first full pay period on or after the written notice is provided, unless the employee agrees. So I've got a client in a completely different industry at the moment who we're working through this, just to give a sort of example. They work on a 10-week roster cycle, but their pay periods are fortnightly. And so this actually creates a bit of a headache in terms of the extent to which they can offer something to align with the roster cycle rather than offering something that starts at the start of next pay period. And the short answer is the employees have got a bit of a whip hand in terms of how that plays out. It might be that you could argue it's not practicable to do it or something, but again, you'd be pretty brave to argue something like that. Okay, so that's the acceptance process. The rejection process, this is where you're saying to the employee, we're not going to offer you permanent employment. You need to write to them and you need to set out the grounds on which you are not offering the employment. These are the reasonable grounds that you're going to rely on. And the relevance of that is that it would tie into any dispute that you may have, because that document can then be disputed by the employer, and we'll touch on that a bit later on. If the employee rejects the offer, if you advise them that you're not going to make the offer, or if you're a small business employer, there's this residual right. So employers with 15 or more employees have the positive obligation, this 21-day window from when the employee first commences. You have that as a positive obligation. This is part of the National Employment Standards. So in the same way as breaching any of the other provisions would apply, this is another one where failing to comply could lead to prosecution. It's possible that the legislation would be interpreted that because there's an out, so the legislation basically says if you don't follow it, you retain the residual right. It's possible that a court might decide that this isn't a clause that can be breached per se. In other words, that the consequences of the breach is just the next line down, but I don't think that's how it's worded, and I would not rely on that at all. So the residual right to convert is roughly the same procedurally. The trigger is the difference. So whereas there's a positive obligation on the employer in the previous instance, this all comes back to the employee actually requesting to convert. So the employee still needs to meet the same broad qualification criteria in terms of being employed for at least 12 months. And then during that previous 6 months leading up to the request being made, they've worked a regular pattern of hours, et cetera, et cetera. There is, as I say, the main difference is the employee has this right to request. So they've got to come to you. It can't be a verbal discussion. It needs to be a written request with certain information in it. But once they do that, it then triggers a similar sort of process in terms of the conversion process. Can the employee continue to do this? Yes, is the short answer. Basically every 6 months. So you can go through a rejection process and be all legitimate. 6 months later, there's another window open or another trigger is available for the employee to make another request. Kind of makes sense in some ways, like they had to draw a line somewhere. 6 months might be a bit shorter than employers probably wanted. But at some point there needs to be a reassessment of the conditions, because you can be a genuine, casual for a long period of time, and then all of a sudden it morphs into something more permanent. And so, yes, you can continue to request once every 6 months. So what's the requirement? Written request. And then what happens to the employer? You got 21 days to respond. Same sort of process. You're either going to say, yep, no worries, here's the offer. Or alternatively, you're going to say, these are my reasons why I'm not making that offer. If you are going to offer it, you go through a similar process. Again, this 21-day window where you need to discuss with the employee, and then you need to provide the written details. And then there's a commencement date, which is either as agreed or the next full pay period. And then if you reject it, same deal, you've got to send a written notice outlining your reasons. Now, the reason, I'll just touch on this slide first. The reason why you need to put the reasons in is because everything under this provision is subject to dispute. If you've got an EBA in place, it is likely that your EBA's dispute resolution process will be the process. That's because EBA dispute resolution processes are meant to also apply to disputes about the operation of the National Employment Standards, of which this is part. Interestingly, if you've got a contract of employment or other agreement that sets out a dispute resolution process, they need to follow that as well. The sort of smart lawyer would say, well, let's give everyone a written contract that sets out a dispute resolution process that's entirely favourable. I'm minded not to. I'm minded not to advise that. And the reason for it is that the Fair Work Commission's processes only consent arbitration. So you can't get rammed into an arbitration unless you choose to. If your EBA provides for arbitration, then you can. But the alternative pressure release for the employee is just to prosecute you for a breach of the national employment standards. And so, for example, if you chose not to go through consent arbitration, the employee might give up, but you give them a stark choice between giving up and going the whole hog. And the going the whole hog option is way less favourable than going to a Fair Work Commission arbitration where you can put your reasons to a test. It's going to cost you the same legal fees, but you don't have the risk of adverse penalty if you're unsuccessful, in addition to whatever other damages might flow in terms of leave accruals and the like. Now, I will just flag there are strong anti-avoidance provisions, so you can't cut someone's hours just to break up the 6 months, and you can't dismiss and re-engage them. And more generally, these are workplace rights. And because they're workplace rights, adverse action then applies. So if you do treat someone less favourably by giving them less hours, discriminating against them, etc., on account of the existence, exercise or non-exercise of this workplace right, then you are liable for adverse action. Now, you can't cover adverse action off in any number of hours in a seminar because it's this unruly beast that has so many different permutations and combinations. But what makes adverse action so nasty is that there's a reverse onus of proof. So if a casual employee, either has made a request or is looking like they're going to meet those qualification criteria, and then you dismiss them or cut their hours or whatever it may be, you've got to prove that it wasn't because of this. It wasn't because of the upcoming casual offer horizon, which is just another bit of complication to deal with. Again, nothing you can do other than make sure your systems and procedures and processes are in place. But also not be overly scared of casual conversion. At the end of the day, if the person is working full-time hours, especially if they're working overtime, it's usually cheaper for the employer to have them on full-time. And look, in the construction industry, if you're worried about labour requirements, put them on daily hire. Engage someone as a daily hire employee instead of a full-time employee. So there are options around how you structure your labour force, bearing in mind, like I say, that I would anticipate the vast majority of people won't accept the offer in any event. So this gets us back to this transitional window. So what we've got is a situation where the way the government has described it is not quite the way the legislation's written. So what the government described as transitional window was that during this 6-month period, you've got to make an assessment of whether or not the person should be offered casual employment. My reading of the legislation is essentially the way they've implemented that broad policy requirement is to say for anyone who was employed as at the 26th of March this year and employed as a casual, on the 27th of September this year, being 6 months and 1 day after the legislation came into effect, that you open the window then for all those people. So you make your call on that date, whether in the 6 months leading up to it, this person was in fact entitled to it. So right now you're in the window. On the 27th of March, letters are going to have to go out for each of your people if you're going to offer them, reject them. And as I said, even if you think they're not eligible at all, I would still send a letter out saying that, because with a lot of these things where you're not really sure what the ultimate interpretation is going to be, there's good practice in terms of having a foot in both camps just in case something takes you further. So that's the transitional provision. Yep.
You would recommend that to somebody who has been made this offer previously?
Yep, unless it was done in this 6-month window.
So getting back to the employee guide, a week to 4 who has been offered permanent and rejected in the past, do you think that it would be best practice to?
I think you're required to, because when you read the actual specific wording of that 6-month sort of cooling off period I was describing, it only talks about offers being made under this part. And so a previous offer by definition couldn't have been made under this part because it was made either under the award or just out of the goodness of your own hearts. So yes, I would definitely do it again. And even if you've been through the process a month before, I'd still send a letter out and say, look, just letting you know, we've been through this process last month, but just for the avoidance of doubt, this provision's come into effect, blah, blah, blah. So you will find these little one-off cases, but for the most part, it will be employees who are there at 26th of March, make a decision about what their employment is, and it's basically letter 1, 2, or 3. And then within each of those letters, what are your reasons? Like the acceptance, fair enough, you probably need to have a contract of employment to attach to it. The rejection ones, that's where the fun and games is likely to begin, and that is especially in construction industry where so much work is project based, that you don't necessarily know what's coming in 6 months yourself, and that's what's going to be tested. We just don't know how willing courts are going to be to accept that at any given time we don't know if we've got more than 6 months work, so we'll never be able to offer casual employment. That's kind of the effect of that, which I reckon the court's probably going to knock off and say, well, that's the nature of your industry and you've got other full-time employees, so too bad. For some jobs like traffic control where it's really ad hoc work, you can sort of comfortably see how that's going to play out. But for more substantial type work where it's not just a bit here and a bit there as required, where it's every day we're coming up to the same site until that project finishes and then the next project hopefully begins, then that doesn't necessarily play out. Although an interesting element of this, which I'm not sure if I've got on these slides, I don't, is what the legislation does do, thankfully, is it fixes up the way service is defined. So previously there was a gap in the legislation where service was defined as your service as an employee. And so if you had someone been casual for 5 years, you put them on the books for 6 months and then you needed to make them redundant, the argument, well, previous service still counts for the purpose of service-based credits. And on a strict reading of the legislation, that was right. So one of the changes they've made is to make it very clear that, once you go permanent, you sort of day dot as far as annual leave, sick leave, notice of termination and severance pay goes. So one of the interesting outcomes of this is if you know that someone's going to be made redundant in the next 12 months, it kind of doesn't matter because there's no severance pay payable for someone within 12 months service. You'd need to give notice of termination of a week instead of an hour. But, in that sense, for the shorter term engagements, there's less risk. Obviously, once you then move, actually, I tell a lie, sorry, not in this industry. In every other industry, sure, but in this industry, there's a definition of redundancy that includes resignation, etc. So I'll take a step back on this award. But from other awards perspective, you've got like a draft person or someone who's not under the on-site construction award. They're the sort of things that might lead to funny outcomes, so that you might reject an offer, reject a request because their position's going to disappear in 6 months' time. But is that reasonable if it wasn't going to cost you anything? And these are the sort of arguments that no doubt will come out as time goes on. So what do you need to do? Few dot points here. Number one is you've got to review your contracts. You've got to make sure you've got the right clauses for casuals. You've got to make sure the casual loading is identifiable. What happens regularly across just about every single business that I've ever seen a pay slip for, casual employees just get paid a casual rate. They don't separately identify the casual loading. If the casual loading is not separately identifiable, then if there are claims for entitlements, they might not be set off or be able to be set off, whereas the legislation clearly allows set off if there's a separately identifiable entitlement. What that means is just important that if you're going to pay an aggregated casual rate, that it's also clearly expressed somewhere, e.g. the letter of offer, you know, your rate is inclusive of the casual loading, blah, 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 just so that it is separately identifiable as a backstop if there are any claims made against you. Second thing is the casual employment information statement. And then the third thing is to prepare for the 27th of September, 2021. Unlike most transitional windows, which say, you know, you can do this in the next 6 months, this appears to be worded as a hard, on this day, every employer in Australia who's got a casual employee or had a casual employee as of the 26th of March is going to have to go through this process, you know, if you've got more than 15 employees. All right, so prepare, look at your employee list, look who's likely to be a yay or a nay. Second one is, to the extent that you're looking at nays, have actual evidence prepared, something that's tangible, so that if you are challenged, you can say, I based it on this. And that might be workflows, it might be number of tenders, who knows? Like there's you know, so many different permutations of this, but the important takeout is that you need to have some evidence. And then the third part of it is to actually have your templates ready to go. And look, just for everyone's reference, if every single employer has to do this on the 27th of September, lawyers like me are going to be really busy. So I'd be suggesting to come earlier rather than later, and I can't see why that would be any different for any other lawyer, whether you use us or anybody else, because everyone's going to be trying to run through the door at the same time. And we're going to be feeling in the dark for a lot of it, because we're doing our best to work out what this all means ourselves. So I would recommend getting in earlier rather than later if you look like you're going to have or need any assistance, and especially if you look at your list of employees and think, God, there's a few complicated cases here, because it's one thing to prepare a few procedural documents, but it's another thing to then have to try and apply that to, you know, unique sets of circumstances, and it will take time. But other than that, we've done our best guess. This is the most important slide when we're standing up here talking about new legislation, because we are just doing it based on, obviously, a fairly detailed understanding of IR history and the way things apply, but everything is subject to judicial interpretation, and especially this casual stuff, we are likely to see some really left field decisions coming from judges who don't necessarily understand the IR side of things and just apply based on a black letter understanding of the law rather than understanding how that might apply in practice. But that's the legal system. You know, everyone thought WorkPac was going to win. It might well be the High Court overturns WorkPac. They've got a history of overturning some of these decisions based on sensible outcomes, rather than based on an application, a strict application of the law. And that's the job of the High Court, is to do that. So they might overturn WorkPac, and it might be that all of this is extra red tape for no practical outcome for employers. But it is what it is, and you're not going to get this out of the legislation in a hurry.
Tom, is that still ongoing then?
It is, yeah. So the High Court, I reckon it was heard in March, and so decisions reserved. All much ado about nothing, but whether it's about nothing or not, there's much ado to be had. So,
Sorry, if we've got a casual and they're entitled to travel, right?
Yep.
Just like everybody else. They, on their first job, they worked outside of the 50K, right? So they wouldn't have been entitled to the super payment, let's say. And then we don't use that casual for a couple of years because they go work somewhere else, let's say. And then they come back to us. Do we start that process again?
Good question. And this is something that we will absolutely relying on some sort of judicial interpretation to have a correct answer to, if at all. When does casual employment end, and when does it not end? Now, the legal position is each engagement is separate, but at least the unfair dismissal law about what a termination of a casual is that there needs to be some act by either party or act or, express or implied actions that lead the other party to reasonably believe that work's not going to continue to be offered the way that it is. Beyond that, then just to be clear, that's not the end of employment. That's talking about when there's a termination at the initiative of an employer. So the short answer is we do not know. The CFMU have argued on transcript exactly what you're saying, which is basically each engagement separate. So this question, is only relevant for, each time you engage this person, you've got to work out whether it's more than 50K. Otherwise, the same rules apply. But we don't know. And yes, it's unfortunate because it's going to be a question that comes up again and again and again.
So at this point, unless they want to be terminated, we wouldn't terminate.
You wouldn't terminate them. Yeah, but well, I wouldn't change your practices based on this. That's the reality, because otherwise you're in that adverse action window. And that's the point, is anything that you do based on the existence or non-existence of a workplace right is a potential adverse action window. Now, the expense is arguably not adverse action if the reason you did it was because of the expense rather than because of the workplace right. And this is the difference between what they call the operative reason and the proximate cause, or the proximate reason. But every time something like that happens, you're in an argument, and that's what you're trying to avoid. Excellent. All right. Well, thank you very much, everybody. As I said at the start, feel free to contact me if you've got any other queries. I'll stay back here afterwards if anyone has any other queries. Good luck. It's like IR law used to be, which was entirely difficult and ambiguous. It's just backed up with really big penalties now, so it's much worse. But that's the game. So, thanks, guys. Cheers.